Hello, I'm Kendra Yak. Welcome to the Education Law Insights podcast, brought to you by Forensic PC. Education Law Insights provides you with insight into the latest education law developments and analysis of pressing legal issues in the education field. Today we're sharing a discussion with the editors of our Forensic Title IX Insights blog, Jackie Werns, Amy Dickerson, and Emily Tulloch. We've heard so many questions about what to expect related to the new Title IX regulations now that we're preparing for a new administration. Emily, what do we know about Biden's plans for Title IX?
Yeah, so even while he was a presidential candidate, Joe Biden really promised on the day the regulations were released in their final form that if he was elected, he would be putting a quick end to the Trump administration's 2020 Title IX rules.
Yeah, and we have no reason to think that he was bluffing. He was a key player in the Obama administration's issuance of guidance on Title IX. And I think one thing we can all agree on is that we can expect that Biden would do whatever he can to dismantle the regulations as quickly as possible. And so where there's less clarity is understanding or predicting exactly how he will aim to do that.
Okay, so Jackie, does this mean schools don't need to follow the current Title IX regulations if Biden is sworn in as expected in January?
Not at all. So these regulations are the law of the land. And so as Emily mentioned, even if, we know that Biden has said that he wants to get rid of these rules. And as Amy mentioned, we expect that he'll probably move quickly to try to do so. Rolling back these rules is definitely going to take some time. And so at the very least, schools, colleges, and universities will absolutely need to use it up to Inauguration Day. But the reality is that even after January 20th, it is not likely that these rules will suddenly disappear.
Okay, so before we get too far into what might change, what are the pros of the existing regs? Is there anything you would like to see remain in place?
One aspect that I think was a positive that these new rules brought is some clarity for schools in terms of what's expected when responding to reports of sexual harassment, particularly for school districts. I know on the higher ed side here in Illinois, we have a state law that prescribes very specifically what schools, institutions must do when responding to reports of sexual violence. And in the K through 12 realm, despite all of the guidance that would come out with regard to reports of sexual harassment under Title IX, there were still a lot of questions. And so I think one thing that the rules do provide from a high level standpoint, where there are lots of specific procedural requirements that present a lot of difficulty for our school district clients, overall having some clarity as to what is expected of them when responding to reports of sexual harassment, I think can be a positive.
Yeah, and I would just second what Amy said about consistency, that, even for schools across the country, so even in the higher education space where we did have a lot more guidance sort of on a piecemeal basis. So as Amy mentioned, in Illinois, we have our state law that tells higher education institutions how they have to respond. We also have federal law, the Clery Act and the Violence Against Women Act, that gives some direction on how you must respond. If you're in the Sixth Circuit, you have case law from federal courts telling you that you must do things like provide live cross-examination in a Title IX hearing. But with these regulations, what we got was some consistency across the country for students and for other individuals who are part of these school communities, to where, regardless of whether you're a student in Alabama or you're a student in California, the Department of Education was telling you what you could expect to be part of this process. And I think overall that is a good thing.
Yeah, and I think that the new regulations really define roles and create training opportunities and requirements that are really positive if we look at the outcome. Training on things like implicit bias or conflict of interest, I think really does end up creating a fair process for everyone involved, because there are so many requirements in terms of, being aware of these types of biases and conflicts as they move through their investigations.
So on the other hand, what are the biggest changes you would hope for if there are new regulations issued? Jackie?
Well, I've been pretty vocal about the fact that, I think that these rules, even though there are some really good elements to them, and regardless of where you stand on the spectrum of whose rights you think should be valued more in this process, I think these rules were, despite the amount of time that was put into them, they were pretty poorly thought out in terms of how they, for instance, how do they interact with existing processes? So whether you are a K-12 school district that has tenured teachers, where you have a state law that tells you certain things you must do before you discipline or terminate a tenured teacher, or you have laws that say how and what process you must use to discipline students through things like suspension or expulsion, or if you're a higher education institution that has tenured faculty where you have processes that you have to use. I don't think there was nearly enough thought put into the interactions. And frankly, a lot of them were like oil and water. They just really don't mix. And so we practitioners have been scratching our heads trying to help schools, colleges, and universities comply with these rules while also complying with the other rules and laws that they are bound to meet. And also, I think just the sheer amount of resources that are expected of institutions, with no funding, and particularly during a COVID-19 crisis, those things are things that I would like to see change, at least be mitigated in any changes that will come.
Yeah, and I think many of our clients have raised concerns in terms of how some of the procedures and the regulations, and particularly when they're applied to K-12 schools, things like written cross-examination, requiring complainants to really repeat details of their complaint, fly in the face of, those K-12 or, even higher ed educators who are really trained to be trauma-informed. They deal with children and students every day. I think a lot of these processes end up kind of flying in the face of that training, and are in direct conflict with some of those best practices that they're used to.
Okay, so if a Biden administration wanted to take some of your excellent suggestions and look to changing those particularly difficult aspects of the regulations, what options are available for them to make changes or to get rid of the current Title IX rules?
Well, so the Trump administration purposefully made its changes to Title IX using administrative rulemaking, and that is a lengthy process. It requires proposing a rule to the public, giving them an opportunity to comment, and then addressing the comments when issuing a final regulation. And as I mentioned earlier, the result is actual law. It's not guidance that a new administration can just walk in the door and easily discard under a new administration. So with that in mind, we do think there are a few options for a Biden administration if they want to unwind these rules. Congress can pass legislation, either amending the Title IX statute or passing a new law that requires schools, colleges, and universities to use different procedures. And that would trump, no pun intended, any regulation that's in place, because laws are sort of superior to regulations. But, even if Democrats somehow were to take control of the Senate, it seems very unlikely that Title IX legislation, a new law, would reach the president's desk, just because of at least under the current rules that allow filibustering. There is a relatively obscure legislative option that is the Congressional Review Act, which sort of gets you around the filibuster drama and would allow a much easier path that would likely be available to a Democratic Congress for legislation. But it can only be used if a rule was either published in the Federal Register or submitted to Congress in the final 60 legislative days of the outgoing Congress. And so the concern here is, when we've looked at, we all sat down and Kendrick guided us through the calendar the other day. When we look at the congressional calendar, it really doesn't seem like this is likely going to be an option, just based on the number of days that Congress has already been in session this term. The other sort of option that's one of these kind of firm would absolutely work to get rid of the rule would be to go through that same notice and comment rulemaking process that the Trump team used to issue their Title IX rule. But it's really important to keep in mind that, candidate Trump promised a new Title IX rule during his candidacy for the presidency in 2016. And for those of you that were watching the calendar, the proposed rule wasn't even issued until November 2018. And then it was almost 2 years later, August 14th of 2020, when the new rule went into effect. So this process is really lengthy. And there's no reason to think that the road to new regulations would be any quicker for President Biden than it was for President Trump. So I've just given you 3 options, all of which I don't really think are very good ones. So I'll now turn it over to somebody else to give us something that might actually work.
So there's also the good cause option. I'm not sure this will be our winner either, but kind of as Jackie was talking about the notice and comment process for these new rules is set forth by the Administrative Procedure Act. And essentially, the Administrative Procedure Act also allows for federal agencies to forego that notice and comment process and publish final rules if they can show what's called good cause. And we've seen this a lot during recent presidential transitions, actually. So, for example, presidential administrations in the final months of their administration push through a lot of regulations in the last couple months, even though the next president may have different policy priorities. And then those incoming presidents, kind of to gain control of the rulemaking process, impose a sort of moratorium on the new regulations at the beginning of their administrations. And we saw this with both the incoming George W. Bush administration and the Obama administration, where memoranda were issued on Inauguration Day, essentially instructing that regulations shouldn't be sent to the office of the Federal Register, to withdraw rules that had not already been published, and to postpone any effective dates of published regulations that hadn't gone into effect yet. And in response to these types of memorandums in the past, a lot of federal agencies utilize that good cause exception to justify their actions to delay effective dates of different regulations or to push through new final rules without notice and comment. A lot of agencies, this process wasn't reviewed when a lot of agencies did this, but at least one court, the Second Circuit, did invalidate a final rule that was created without this notice and comment procedure under the good cause exception, stating really that no emergency existed, to suggest that good cause was warranted in that case and that they should have gone through the full notice and comment period that Jackie mentioned can take quite a while. So really the big takeaway is that if an agency issues a final rule using the good cause exception, the new rule is binding on the public without following that notice and comment procedure or requirement. So even if litigation did somehow ensue after that, challenging that new rule that was pushed through, the public would still have to follow that final rule that the agency put out. Courts across the country have been really split when reviewing federal agency invocation of the good cause exception. And so, some litigation has resulted in the new rule being rescinded, others have left the rule in effect. So really the takeaway is that if a final rule is pushed through using this exception, it's going to be the law of the land for the time being until a court says otherwise. And I'm not sure that this is our winner, like I said before. So Amy, if you want to give us maybe another option that might come through.
Yeah, well, we could see some other option in the new administration could choose to not enforce the regulations and signal to educational institutions that there would not be then a penalty from OCR for non-compliance, essentially meaning that the institutions would not risk federal funding if they did not comply. The administration could also issue non-regulatory guidance, so in the form of Dear Colleague letters or Q&As that we've seen in the past, interpreting the current laws and the current law and regulations. So as Jackie points out in our Title IX blog post, these options may still leave many questions open for institutions if the current regulations still remain in effect, while also getting guidance that may not be consistent with the regulation. So, while none of us have a crystal ball, if we had to guess, we suspect it, may very well be that we'll see some combination of guidance that narrows the interpretation of the existing regulations, while then also see a proposal of new regulations that go through the 2-year notice and rulemaking. But it will remain to be seen what actually transpires.
Okay, so a lot of options, and none of them seem like, anything is going to happen all that quickly or necessarily be super clear. What should schools and colleges and universities do now?
Well, so as I mentioned earlier, until January 20th, which is Inauguration Day, everything stays the same. The new Title IX rules are still the law, and you should still, if schools, colleges, and universities should still be processing reports and formal complaints under Title IX using the Trump rules. You should be continuing your training to make sure that you're getting that completed. You should make sure that your policies and procedures and your websites are all up to date. Definitely contact us if you have any question about whether any of those things have been done, because we have seen organizations going after schools, colleges, and universities for failing to comply. So it is important to make sure that you are following these regulations until then. And then if and when the Biden administration explains its plans about how it will address Title IX, what we're going to be looking for, as Amy mentioned, is an option that is going to give some clarity to schools that we aren't going to face liability if we don't use the Title IX rule that is on the books. That is the best case scenario of what we want to hear from a Biden administration, is not just, hey, we're assuring you that you're not going to lose your federal funding if you don't use this rule. That's great. Even better is if OCR tells us, here's what we want you to do to comply with Title IX in our eyes. But when it comes down to it, OCR enforcement is only one type of enforcement of Title IX that we have to worry about. We also have to worry about whether a party to a dispute, particularly a respondent, is going to go to court and say, regardless of what OCR has said, my educational institution should have followed the rules that are on the books. So when we hear what the Biden administration does, please contact us or your other legal counsel to make sure that you have a handle on what it actually means for you before you react.
All right. Thank you, Jackie, Amy, and Emily. And thank you to our listeners. I hope you found this session helpful as we navigate this extraordinary school year. Don't forget, you can sign up for upcoming webinars and get more insights at franzic.com.